just have the appellant's skeleton argument at paragraph 50 to hand, and we see there that this ground concerns a number of evidential matters, and there are 6 evidential matters on which they rely in support of the argument that the judge should have found that the business opportunity was in the public domain, even if Illiquidx's construction of public domain is the correct one. Now, an important starting point is obviously to focus on the nature of the business opportunity as found by the judge. But before we come to the judgment, it's helpful to look at the AICF presentation, which was sent to potential investors in August and September 2019, and which the judge found to contain key elements of the business opportunity. And perhaps if you could just see item L of the schedule to the judgment at Core Bundle tab 7, page 129, where he's dealing at the bottom, item L, bottom left, with the AICF presentation, part of the fund detail, and consists of 27 slides. Is it Illiquidx's confidential information? Yes, this was conceded by defendants that as a whole this is confidential information. Is it permitted disclosure pursuant to clause 1.1? No, for the reasons given in the judgment of paragraphs 100 to 103. Has there been misuse? Yes, this sets out key elements of the business opportunity which the defendants have exploited. And this is one of the document, the AICF presentation, is one of the 6 documents which, if we just go back to paragraph 99 of the judgment, this is one of the 6 documents which the judge termed the fund detail. And his unchallenged finding at paragraph 99 in the final 4 lines was that the collation of information to formulate a rationale for the idea...
Sorry. You're going just a fraction too quick.
I'm so sorry.
You said this was one of the 6 documents, but he doesn't define those in 99.
I'm so sorry, paragraph 91.
Yeah. Right. Yeah. So, okay, got that. Thank you.
So he defines them in 91, and then in 99, he says 4 lines from the end, the collation of that information. So this is in paragraph 99, he's dealing with the business opportunity itself, was not published by IX or the defendants as a collation of information except in the fund detail, the collation of that information to formulate a rationale for the idea of a sanctions-compliant fund to invest in Venezuelan debt was only available in the fund detail documents. So that's the significance of the fund detail documents. And so can I just now take you to the content of this particular document so we can have a little look at it, because you haven't yet, you've seen legal disclaimers, but you haven't actually seen the substance of it, and it's in the supplemental bundle at tab 22. And if you go to page 113, it sets out what's there referred to as the opportunity. And it sets out various factors, all of which came from Illiquidx, that made this such a unique opportunity at this time. So you can see in bullet 1, Venezuela is experiencing severe economic crisis. 2, historically, sovereign defaulted debt has provided superior risk-adjusted returns for investors. 3, previous defaulted sovereign bond debt has traded 20 to 40% with illiquid claims at a discount, eventual recoveries, etc., etc. Wealthier nations such as Venezuela would be expected to be at the higher end of the range. However, US sanctions have removed the largest buying base and increased the number of sellers, meaning claims and debt can be sourced at 10 to 20%, potentially delivering 400 to 800% returns and IRRs of 30 to 50% over a 5-10 year horizon. And then at the bottom, importantly, this is the first time we have ever seen distressed sovereign debt under US sanctions, and one of the few times sovereign debt could be bought at such advantageous terms. And then if you look at the next page, background, page 104, and in particular under timing, and the first bullet, US sanctions have caused already distressed government and corporate Venezuelan bonds to dive further. with US regulated creditors banned from dealing with Venezuela and PDVSA, the market has become highly illiquid, wide range of investable assets, a mild attempt to overthrow the government, and then in the bottom, both a relaxation of sanctions and normalization of export and financing activities, or a complete change of regime will lead assets to reprice upwards. If you then go over the page to 115, why invest in the Kanema fund? And you then see in the first bullet of the, and there are various sub-bullets, you see reference to a sanction-compliant investment vehicle, understanding and verification of claims, collective action clauses, legal processes, managing value recovery and monetization. Then the next substantive bullet point, very sizable pool of assets. And then at the bottom, hard to access investment opportunity for individual investor facing higher transaction costs and more limited recovery strategies. Additionally, due to language in the bond prospectus, claims become void unless active legal representations are made by the bondholder. This is dealing with the limitation point. And if we go to page 121, there's further material on limitation. Here, it's debt legal overview. And if you just look at the third bullet from the end, what we're doing is, this is dealing with limitation periods in relation to both interest and principal. And it then says, if the debt instruments are not properly managed, the passing of time would provide a complete...
Your pardon, I haven't found that. Where is that, please?
I'm sorry, 3 bullets from the end. The second sentence, therefore, if the debt instruments are not properly managed, and so on. Historically, most sovereigns have not enforced these rules and paid all creditors regardless, but Argentina, in their 2015 settlement, enforced their rights, and many claims were declared void since they become time-barred. The Altana Illiquidx Kanema Fund will assist you not only in providing unique access to promising return opportunities in the distressed sovereign debt of Venezuela, but also managing the debt instruments to protect creditors' contractual rights with the aim of achieving a greater return. So, my lords, what this document is doing is highlighting to potential investors the unique nature of this exceptional commercial opportunity to buy distressed Venezuelan debt through a sanctions-compliant fund, which would be set up for that purpose. And as you see, it identifies various strategies for unlocking the opportunity, including dealing with limitation on behalf of potential investors. And as we've seen, the judge found in item L of his schedule that the document contained key elements of the business opportunity. Now, the appellant's position at trial was that they took numerous pleading points, the punchline of which was they really didn't understand what the business opportunity was or how the documents pleaded in the detail fitted in. But that if, contrary to that primary position, there was a coherently pleaded case which we could advance, then the business opportunity was a staggeringly trivial idea. It was also in the public domain, as were all of the individual strategies for exploiting it. And crucially, Mr. Robinson and Altana knew all about the business opportunity, and they'd been following the Venezuelan situation since long before Illiquidx came along to them with the idea, and they were simply waiting for Venezuelan debt to hit 15 cents on the dollar before jumping. Now, the judge, having seen the documents and having heard the evidence, in particular Mr. Robinson's evidence, found that Mr. Robinson's evidence was simply a lie. And the position was that he and Mr. Kastner knew nothing about the commercial opportunity being presented to them until Illiquidx brought the idea to them and educated them about it and about how to exploit it. And this document contains key elements of what Illiquidx had brought to them, the value of which they now appreciated. Now, in various paragraphs of the judgment, the judge then set out the crucial process by which Illiquidx brought the idea and the strategies of exploitation to the appellants, who initially knew nothing about it, were very sceptical, and then bought into it. And it's important to keep those paragraphs in mind. And can I just take you to them, just a handful of them, in the judgment at tab 7, and starting at paragraph 21. And the judge there says, he's talking about Mr. Robinson's evidence, and he says he claimed to be amply familiar with the existence and exploitability of Venezuelan debt prior to any contact with Illiquidx, and that he had nothing to learn from them. He claimed to have had a clear view prior to contact with Illiquidx that he would be interested in investing in Venezuelan debt when it hit the price of 15 cents a dollar of debt. He claimed that he and Altana had conducted significant research into Venezuelan debt prior to the NDA with Illiquidx. They independently verified anything Illiquidx told them. All of these claims are not consistent with the contemporaneous document. See paragraph 38 below, and I found his explanations in cross-examination not credible. Mr. Robinson explained contemporaneous documents showing him asking questions apparently displaying his unfamiliarity and lack of knowledge of Venezuelan debt, as is asking probing questions, the answers to which he knew to test IX's knowledge. Mr. Green called this the test the rookie's explanation. I reject the test the rookie's explanation. It's quite clear to me that in relation to Venezuelan distressed debt, Mr. Amore and Miss Alabachka were the experts and Mr. Robinson and Kastner were the novices. Mr. Robinson said as much to investors. They're the experts. As for the target price of 15 cents, when taken to correspondence in July 2019 indicating Mr. Robinson's interest in investing himself if prices fell below 20 cents, thereby contradicting the notion that he'd already a fixed target of 15 in his mind, he became evasive and was ultimately unable to explain this contradiction. And if you then go to paragraph 25, having dealt with other parts of Mr. Robinson's evidence, he says, I'm unable to accept anything said by Mr. Robinson unless it's corroborated by the contemporaneous documents. If you then go to paragraph 38, to which he referred in paragraph 21, it reads, despite Mr. Robinson's protestations otherwise, it's clear from the contemporaneous evidence that Mr. Robinson and Mr. Kastner, the latter does not contend otherwise, had very little idea about Venezuelan debt at this point in time. For example, and he refers to a transcript where Mr. Kastner does not appear to have known anything about sanctions, their impact on US investors, or that bonds could still be bought by non-US persons. He didn't know about PDVSA, etc. And then little 2, which is particularly important. On reviewing the Kanema Capital presentation, this is obviously one of the 2 marketing documents on which my learned friend relies. Mr. Robinson's email to Mr. Kastner shows he was sceptical as to whether it was possible to get round US-EU sanctions. In other words, he did not at that stage know that Venezuelan sovereign bonds and PDVSA bonds could be traded, despite the sanctions in place. Then 3, the transcript of the 10th of May calls shows Mr. Amore explaining to Mr. Robinson, who didn't know how certain Venezuelan bonds could be traded through Euroclear and how the EU sanctions operated. Mr. Robinson appeared to have no knowledge that the bonds could be traded, who was permitted to trade the bonds, or how the trades could be executed. On 4th of June 2019, discussing the fee splits with Mr. Kastner, I think we both acknowledge that we need them more than they need us to get this off the ground. We don't really have an alternative for them at this stage, whereas they're more likely to find a backer. Now, just pausing there, my lords. So even though it was in the public domain that 38 bonds could be traded, Mr. Robinson, an expert in distressed debt, didn't think they could be traded, and he was sceptical as to whether you could get round sanctions, and therefore did not appreciate that it would be possible to set up a fund.
Does that in itself matter? Suppose a particular item of information is in the public domain, but prior to being told that information, the defendant doesn't know it. The fact that he didn't know something that was in the public domain, and he learns it from the claimant, doesn't disinhibit him from using that information.
I entirely accept that, my lord, but in circumstances where you're talking about somebody who claims to be a particular expert in the area of distressed debt, including Venezuela, and he knows absolutely nothing about it, it's a pretty strong indicator that something odd is going on, and perhaps it isn't in the public domain. But I entirely accept that it's not utterly determinative.
Well, the judge has decided that he didn't know about Venezuelan debt.
Well, yes.
So,
well, that's
the premise of what you say is, here's a man who knows all about Venezuelan debt, but he doesn't know about this.
Well, he knows all about distressed debt. He
may not have thought about very much about Venezuelan debt.
No, I agree. I agree. And that's why I can't place too great an emphasis on it, but it's certainly it's certainly in tension with the suggestion this was all in the public domain. If supposed experts in distressed debt, including in South American debt, didn't know about it, it is at least somewhat surprising. It's certainly not a situation where one can go, it's absolutely blindingly obvious that because 38 Venezuelan bonds could be traded, therefore it's in the public domain that you could set up a fund to trade them. Mr. Robinson had no such idea.
You don't challenge the judge's finding
No.
that the 38 bonds, that the fact they could be traded was in the public domain?
No, absolutely not. We don't challenge any of the judge's findings. Can I then take you to paragraph 41? And this is where the judge records the fact that the 38 bonds were sent by us to... sorry, I'm looking at 42. 41. After executing the NDA, the parties held a meeting on the 9th of July, which Mr. Kastner recorded in the form of notes, the due diligent note. This is item B of the detail. Mr. Kastner distributed the note on the same day. I prefer the evidence of Mr. Amore and Mr. Alabachka as to this meeting and this note. This was a dump of information by IX on Altana. Now that the NDA had been signed, Mr. Amore talked through the US and EU sanctions and the mechanics and feasibility of various types of trade, recovery strategies, and the possible competition. His briefing included the idea of obtaining a legal opinion that the fund was sanctions compliant to reassure investors and financial institutions dealing with the proposed fund. If you then go to paragraph 46, and this is now by July, August, Mr. Robinson and Mr. Kastner were by this stage fully persuaded of the lucrative nature of the opportunity. After his initial scepticism, by the end of July, Mr. Robinson was describing Venezuelan distressed debt to potential investors in the AICF as the best distressed sovereign trade I have ever seen, and the distressed trade of the decade. And if you then go to paragraph 105, which is on page 117, sorry, it starts at the bottom of page, it starts in the middle of page 116. I reject Mr. Robinson's evidence that he always had in mind the creation of a Venezuelan debt fund when the bond was right. There's no document disclosed by Altana in the 12 months prior to meeting Illiquidx in which there's any research or discussion of trading Venezuelan bonds at all, never mind setting up a fund. The suggestion that Mr. Robinson had done the research, was waiting for the price to hit 15 and kept this research and analysis entirely in his head, was highly implausible, contrary to his own evidence that he kept a written record of everything important, contrary to the contemporaneous documentation, where he presented the AICF as the trade of the decade in which he intended to invest at 15. And then we've got Mr. Kastner's evidence. Nor did Mr. Kastner give evidence that he had been told by Mr. Robinson of such a plan. And then at little 4, I've already observed the transcript of the first call with Mr. Amore shows Mr. Robinson was a novice in relation to Venezuelan debt. Mr. Robinson is recorded in the contemporaneous documents as referring to the idea as Mr. Amore's idea, and to having been educated by Mr. Amore. See the mercantile call transcript. Mr. Robinson and Mr. Kastner agreed in an early stage that they needed IX more than IX needed them. And then at paragraph 106, which I've already taken to you, I'm satisfied that prior to their contact with Illiquidx, neither Mr. Robinson nor Kastner were aware of the ability to create a sanctions-compliant fund in distressed Venezuelan debt, reinforces the point that this was not information in the public domain if someone of Mr. Robinson's expertise was not aware of it. It also confirms they took the idea from Illiquidx, as there are no other alternative sources for that idea, and that picks up the point that I was dealing with my Lord Justice Miles a moment ago. We don't say it's determinative, but it's certainly indicative. It is also, I should just say, there is no appeal against any of the findings in the paragraphs I've taken you to. It is also important to note that when the appellants decided to set up and market their own fund, they presented it to investors as an extraordinary commercial opportunity. And can I just take you to one paragraph in the judgment? and it's paragraph 61 on page 104. And on the 3rd of March 2020, so we're in the following year, Altana distributed a marketing email for the ACOF, the March ACOF marketing email. The email referred to the trade of the new decade, Venezuela, and advertised, "While we've been talking about the trade since last summer, it has taken us months to set up the fund. Very few custodians are willing to open new accounts, even though we have a legal opinion clearly stating we're sanctions compliant. We have renamed the fund, avoiding direct mention of Venezuela." And so the message was that this was a unique commercial opportunity, trade of the decade. It was extremely difficult to set up a fund to exploit it. Very few custodians are willing to do this. And we're not going to mention Venezuela because we don't want to spook people. So the pitch was very difficult to reconcile with the case that the business opportunity was all in the public domain. Now, what of course was in the public domain, as I've already said, was that it was possible to buy sanctioned Venezuelan debt, the 38 bonds, i.e. if you weren't a US person or entity. But the business opportunity was very much more than that, as we've seen from the AICF presentation. And let's now come to the judge's specific findings on the business opportunity. And can we start with paragraph 84? And what he says there is that, about 3 lines from the end, the pleaded case, I ruled at the pre-trial review, the pleaded case is that the business opportunity is composed of the information listed in the detail. So the business opportunity was comprised of the information set out in the detail documents. If we then go to paragraph 86, now in the second sentence, starting the business opportunity, and the third sentence, in those 2 sentences, he's articulating the case that I was focusing on in closing submissions. And in the third sentence, he makes clear that as he understood it, the case being run was that the business opportunity, as articulated in the second sentence, was valuable because it was not common knowledge in the market this could be done, and Illiquidx had the know-how to overcome the apparent obstacles in the way. And he then says that he accepts the change of emphasis, i.e. as articulated in the above 2 sentences. He accepts that that change of emphasis is within the pleaded case, and that my learned friend didn't argue otherwise. And he then says this is because a sanctions-compliant fund, as a means of unlocking value, is described as part of the package of information comprising the business opportunity and confidential in its own right. And he then cites various passages in the pleadings and various documents containing the detail. So he's not defining the business opportunity as simply confined to the second sentence, but he's making clear that it includes the know-how, the means of unlocking the value in the business opportunity, as pleaded and as contained in these documents, and as we saw in the AICF presentation. And this is also clear if you look at the schedule. So if we just go to paragraph 124. And if you look at item B, so this is the due diligence note that we've just seen the judge referring to. And he says in description, it's a note which recorded information provided by Illiquidx, has 14 items. Item 6, the actual mechanics and feasibility of trades in different assets. Is it IX's confidential information? Yes, conceded by the defendants where the information is specific. Is it permitted disclosure? No, the package of information delivered at this meeting was not known to the defendants. They were not aware of the mechanics, feasibility of trades in different assets, asset classes, or the potential recovery strategies. While some of the information may have been publicly available if one knew where to look, the collation of information as to what could be traded, notwithstanding US sanctions, by whom and with whom, and how to do it, was a collation of information which was not readily or easily accessible. Misuse, yes, the specific information about the mechanics and the feasibility of trades in different asset classes and the potential recovery strategies formed part of the business opportunity which the defendants had exploited. And again, there's no appeal from this. If you then look at item H, this is the fund fact sheet. Is it confidential? Yes, conceded by the defendants. Is disclosure permitted? No. And then you've got misuse, yes, sets out key elements of the business opportunity. Again, no appeal from this. And if you go to L, where he's dealing with the AICF presentation, and we've seen this, yes, sets out key elements of the business opportunity. Again, no appeal. And then item R, claim management presentation. Misuse, yes, the use of multi-cell structure was part of the business opportunity. So it's clear that the judge regarded these items of the detail as part of the business opportunity. So it wasn't simply the idea, the single sentence idea without more. And when my learned friend said yesterday that the schedule is only about the detail, that's just wrong. It makes clear where a particular item of the detail is a component part of the package. Now, can we then come back to paragraph 86?
Just before we do that,
Yes.
can you help me on this? I mean, if one looks at paragraph 84,
Yes.
what's said there is the business opportunity is composed of the information listed in the detail. The detail comprises documents limited to passive documents identified in the pleading. Now, a judgment is not a statute, and no judge should be picked up on niceties of wording. Nevertheless, if we take what is said literally, he seems there to be saying that the business opportunity consists of the entirety of the information listed in the detail. In other words, items A through to, is it W? Yes, W. And yet, his ultimate conclusion seems to be that there is a misuse of the business opportunity because there is a misuse of a subset of the items in the detail. It might be said there's a tension there.
Well, yes. I'm not sure that's right, my lord. I mean, firstly, he is saying that the broad high level, the single sentence idea and concept has been misused. But he's also saying, as I find elsewhere in my judgment, there were other elements, other investment strategies, other features of the business opportunity. Those too have been misused. So it's a combination of both that have been misused. Because also what would happen in relation to the detail, if ultimately it were to be found that there hasn't been an exploitation, a misuse of the business opportunity, but there has nevertheless been a misuse of, for example, Professor Olivares Caminal's legal advice, we would still be entitled to damages in relation to the misuse of that one single item, but it would be tiny damages. So he was considering it both from a macro perspective and also the micro perspective. But he is...
All right, but can we just try and tease that out a bit?
Yes.
You referred there at the beginning of that answer to a finding of, I think you said the single sentence has been misused.
Yes.
And can we just try and be precise about what you mean by
Yes.
that as the single sentence?
Absolutely. My learned friend is trying to confine everything to the single sentence in paragraph 86. The business opportunity he submitted was the opportunity to set up a sanctions compliant fund. He's saying that's it. That's all the judge has found as the business opportunity.
Well, and as you point out, in the schedule we find more. And I take that point, but I'm just trying to see where all this goes to. Is it your submission that the single sentence is a pleaded item of confidential information which the judge found to be misused? Before we get into the detail, take that on its own.
Yes, we do. But we also, our position is that what we will now see is that the judge actually found that the business opportunity was broader than that. It included various investment strategies. We're about to come to paragraph 91 in a moment. And so the judge's finding was that the business opportunity was wider than simply the single sentence.
Right. Okay, so you put it both ways round, and that I understand. Let's look at the more detailed way you put it, which is, even if it's not open to the judge to make a finding based on the single sentence in 86, you say he didn't stop there, he made a broader finding in your favour. And that brings me back to the question that I was asking before, because this is always one of the problems one gets in collation of information cases. Because if you have a collation of information that is alleged to be confidential, take an arbitrary number, it's 4 items, just keep the number small to make life simple. Is the confidentiality, does it reside in the 4, so that there is not a misuse if you take 3, or does it reside in each and every one, in which case there's a misuse if you take 1, or can you have any permutation? And at the end of the day, that is always essentially a question of pleading, and then proof of what is pleaded. So this is why, particularly in collation of information cases, it is necessary to have quite a clear focus on what the pleading is actually saying. And that's why I was asking this question about what the judge said in paragraph 84. Well, because on one reading, that could be suggested to be a finding that the business opportunity consists of all the information in detail.
No, he clearly...
And not... Well, all right, but is it your submission that it's any one item is enough?
Any one item is enough. What all the judge was saying in paragraph 84 is that we were tied to the information that was pleaded in the detail. Not that we have to establish that every item of the detail has been exploited in order for us to get home. And indeed, his whole judgment makes it absolutely clear that he didn't take the view that we need to succeed on every single item of the detail, because we didn't succeed on every single item of the detail, but yet we succeeded. So he clearly wasn't saying that we needed to get home on every item of the detail.
Right, and am I right in understanding that your bottom line is that even if one ignores the more high-level case, there is a finding of a package of information, and if one looks at the schedule, you looked particularly at B, H, L and R, but in fact there's a bit more, because you can also rely on the findings in relation to, for example, M, and I think there's one more, yes, M and N. You say there's a package there that is protectable.
Yes, absolutely. And the judge so found. Can we first of all, before we come to paragraph 91, paragraph 90, the business opportunity, the opportunity to set up a sanction-compliant fund to exploit undervalued Venezuelan debt, confidential information, IX's idea and concept, and so on. It's deemed by the NDA to be confidential, whether it be treated as such for purposes of equitable duty. No appeal against that. But then come to paragraph 91. Now, there was some debate with my learned friend about this yesterday. And let's just start with the first sentence. Now, when the judge refers to details of the business opportunity, such as Illiquidx's idea of creating such a fund, the rationale for it, Illiquidx's proposed structure of the proposed fund, including the use of multi-sell strategy, he's making clear that these are details of, i.e. they are part of, the business opportunity. And note that they are details, plural, of the business opportunity, not the detail, which was a defined term in the pleadings to refer...
So we read that meaning particulars, do we?
Yes, exactly. And the pleaded detail was, as I've said, a list of documents, whereas the details he's referring to are the elements of what made this a commercial business opportunity, i.e. the rationale, the proposed structure, and so on. So that's what he's doing. And so the business opportunity is clearly not the single sentence articulation contended for.
Yeah, and this is helpful, but I'm sorry to just trouble you on points of detail. Can we just marry up? You rightly noted earlier that there's 6 items in paragraph 91. Could we just be clear as to which items in the schedule they correspond to?
Ah, right, yes. The Kanema capital presentation is item A.
Yeah.
Then the 17th of July slides are item D. The AICF presentation is item L. The 12th of August fund fact sheet is item M. And the claim management presentation is item R.
We seem to have missed one.
Oh, have I?
Well, maybe I missed it.
In my assignment.
Maybe you said it, but I missed it.
Right.
I've written down 5, A, D, L, M, and R.
A, D, L, M, and R. I think, was there...
There's 2 fact sheets. I think you ended up with 1.
Right.
So there's the 12th August fact sheet and the Kanema Fund fact sheet. Which...
have I missed out the Kanema Fund fact sheet? You're absolutely right.
Kanema Fund fact sheet is M.
M.
Where's the 12th August fact sheet?
The 12th of August fact sheet...
That's H.
H.
That's the one I was missing. Okay, fine. So, and you've got positive findings on each of those?
Yes. And no appeal against the findings either in relation to those or indeed in relation to the findings in paragraph 91. Now, if we can then go to paragraph 95, and in line 4, the judge says the business...
So I'm sorry to keep interrupting you, but...
No, not at all.
I just need to sort of ask questions while things are in my mind.
Yes.
Because otherwise one loses the thread. So do I understand you to be saying, therefore, that what the judge has done in paragraph 91 is to say there are particulars of the business opportunity in these 6 items of the detail, those 6 items being compendiously referred to the fund as the fund detail, and you have a finding of both confidentiality and misuse in relation to that package.
Exactly. The fund detail is a subset of the detail.
Yeah, indeed.
Yeah.
Okay, I think I've understood. Thank you.
Now, can we then go to paragraph 95? And so line 4, the business opportunity, the opportunity to set up a sanctions compliant fund to exploit undervalued Venezuelan debt was not widely known in the market. Now, yesterday, my Lord Justice Zacaroli made the point that this implicitly includes the how to set up a fund. And we say, absolutely. And indeed, it's clear from the paragraphs we've just looked at, including the schedule, that the business opportunity, as found by the judge, included the know-how to which he's referred elsewhere. And importantly, there is no appeal against this factual finding, nor indeed is there an appeal against this factual finding 2 sentences down, that very few people knew that setting up a sanction compliant fund to trade Venezuelan debt was possible. We then come to paragraph 96, and I just want to identify the last sentence. Far from identifying, so he's dealing here with the Venezuela article that my learned friend took you to yesterday. Far from identifying the business opportunity, it reinforces the fact that even amongst commentators on Venezuelan investments, the opportunity to trade in Venezuelan sovereign debt was not widely known. Now again, there's no appeal against that finding, although yesterday my learned friend launched a fairly full-throttled attack on it. If we then go to paragraph 99, and the first sentence, the business opportunity was not published by Illiquidx or the defence as a collation of information except in the fund detail, and then towards the bottom have the collation of that information to formulate a rationale for the idea of a sanctions compliant fund to invest in distressed Venezuelan debt was only available in the fund detail documents. Now again, no appeal against that, and it makes clear that the business opportunity is a collation of information including the rationale for the idea. And can I just take, my lords, to a few paragraphs to see what the judge had to say about some of the collated information? Because we've seen the AICF presentation referring to the benefits of investing in a fund that would manage limitation periods for investors. And can we just go to 3 or 4 paragraphs, paragraph 52, starting there. And
I also note, just as these points arise, that at the end of 99, the judge says this: the defendants accept that the collation of information in each of the fund detail documents is confidential information. And I don't think there's a challenge to that.
no. No, there's not.
Finding or note of the defendant's acceptance.
Sorry, there's no note of the defendant.
Sorry, there's no challenge
to the finding
way that the judge puts that.
No, there isn't, my lord. So, I do apologise, my lords. This is taking some time. I will probably be about another hour and a quarter, I would guess.
All right.
Paragraph 52. On the phone call, Professor Olivares Caminal and Mr. Amore explained that the Venezuelan bonds used a fiscal agency rather than trust structure. This meant... Well, shall I leave, my lords, just to read that paragraph? And then if you go to paragraph 53, on the 11th, 4 lines down, on the 11th of September, Professor Olivares Caminal provided a short 1-page note on the effective limitation periods, the consequential advantage of the proposed JV fund, which could protect investor rights. And this is obviously the limitations document, which is to which I'll come a little later. And the schedule deals with items W1 and 2. And if you could just go to 1 and 2, which we find on pages 134 to 135, right at the bottom of 134. So, under is disclosure permitted, a fiscal agency structure meant that it was the responsibility of the bondholders to bring proceedings to prevent their claims to interest or capital becoming time-barred. A sanctions compliant fund would have the advantage for investors of being able to bring proceedings on their behalf to avoid prescription. The defendants were only aware of the issue because they were educated by Mr. Amore and Professor Olivares Caminal. Mr. Robinson regarded the competitive edge it conferred as a diamond. Although Illiquidx published information in its newsletter about prescription and fiscal agency, this diamond was not in the public domain. And then just going back, misuse. Yes, this is information used by the defendants in the marketing and operation of ACOF and is sufficiently pleaded, and no appeals to this, and similarly in relation to W, Professor Olivares Comenal's legal advice, trustee versus fiscal agency memo, where the judge again finds misuse. This is information used by the defence in marketing and operation of the ACOF. And as I say, no appeals to these factual findings. Then if we go back to paragraph 54, and a reference to the claim management presentation, part R of the detail, which explained the proposed multi-cell structure of the AICF, which would allow existing holders of Venezuelan debt to invest in kind in the AICF by exchanging their debt for shares in the relevant cell of the AICF. This presentation explained the protection conferred by the multi-cell structure and the advantages of AICF being able to bring litigation on behalf of investors. And then can I ask my lords to read paragraph 55.
I really hesitate to interrupt. And everyone keeps saying there are things that we haven't challenged on appeal, and I'll address you in reply on what I said. But that particular point, when he was referring to Olivares Comenal, that's point 6, ground 2 of our appeal. We've addressed that. It's challenged directly, the finding in relation to Olivares Comenal.
Well,
how it can be said not to be something we've challenged on appeal?
There is no challenge to these scheduled items in the grounds of appeal. So, can you finally, we've seen these important features of the business opportunity as found by the judge, can you finally then just go to paragraph 104 of the judgment? And there the judge says, on the face of it, there is clear misuse of the business opportunity and the fund detail. After the breakdown of the JV, the defendant simply carried on setting up the fund envisaged by the JV, called it ACOF, to invest in the same assets as the AICF could have invested in and use the same corporate vehicle. They used the rationale for the AICF, which was identified in the fund detail, and the competitive edge given by knowledge of the need for protective proceedings, which was also identified in the fund detail to market the ACOF. The ACOF implemented the strategy in relation to bonds identified in the fund detail, filed claims in New York in accordance with the IX confidential information about fiscal agency and prescription. Put simply, Altana and Brevent appropriated the business opportunity to themselves and exploited it. So they didn't just set up a fund to trade Venezuelan bonds, which would itself have been a misuse of the business opportunity, but they set it up and they marketed it using the very strategies which had been provided by Illiquidx. Now, again, there's no appeal against any of the findings in that paragraph. And of course, when it came to the trial, Mr. Robinson lied about the business opportunity, claiming not only that it was all in the public domain, but that he knew it all. Now, before I now come to the 6 items, can we just take a step back and consider what my learned friend is trying to achieve by seeking to persuade your lordships that you should consider the business opportunity as simply the single sentence articulation rather than the formulation set out in, for example, paragraph 91. Now, it is absolutely clear from the judgment that Illiquidx did bring to the appellants not just the single sentence articulated idea, but also the rationale and all the other elements that made this a diamond and the trade of the decade.
So when you say the single sentence, I think you're interpreting that as just the idea.
Yes.
Without any explanation of how you would do it.
Exactly. That's the way my learned friend is trying to...
That's how you're... What's what you mean by the single sentence?
Exactly. Exactly. And it's also absolutely clear that the appellants knew nothing about any of these matters before Illiquidx brought both the idea and the other elements, the know-how, to them and educated them about them. That's all clear from the judge's findings. Yet what my learned friend is asking your lordships to do is to ignore the facts as found by the judge and to determine this appeal on the basis that the only thing that was brought to the appellants was the single sentence idea, which they then claim, wrongly in fact, was already in the public domain. And they seek to achieve this because they know that they can't establish that the collation of the key factors, so the idea of setting up a fund, the rationale, the proposed structure, prescription, they know that they can't show that that collation appears anywhere in the public domain. And my learned friend hasn't sought to argue otherwise. And instead, what he does is he adopts the salami slicing exercise, i.e., knowledge of buying Venezuelan debt was in the public domain, see the 38 bonds. Prescription was in the public domain, see document X. Limitation was in the public domain, see this. But he knows that he can't show that the collated package of what the judge found was brought to them was in the public domain. And that's why he tries to confine our case in this way. Now, that is breathtakingly unmeritorious and would be a quite remarkable triumph of form over substance. So it's effectively saying ignore the factual truth as found by the judge and just focus on the procedural form. Now, if the judge had made a finding that Illiquidx had abandoned its case and focused only on a single sentence idea to the exclusion of all else, my learned friend might at least have a basis to invite your lordships to adopt that unmeritorious approach. But the judge didn't make that finding, and my learned friend doesn't have any basis for inviting you to adopt that approach. Now, can I now come to the 6 items? And can we just start with the grounds of appeal themselves in tab 1, core bundle tab 1, page 17. And what I'm going to do is I'm going to start with the second of the 6 items. So item 2, little 2. And so this is a reference to the AICF presentation and to the fund fact sheets. And can you just go to my learned friend's skeleton argument at paragraph 56, where he deals with this. And what he says is the judge considered the AICF presentation and the Kanema Fund fact sheet, paragraph 102. He referred to the boilerplate confidentiality wording in paragraph 4 and the words private and confidential at the bottom of the fact sheet and held that the presentation was not put on the website or sent to the wider newsletter circulation of IX or Altana. It remained relatively secret because it wasn't circulated more widely, was not intended to be, and was not available to potential competitors to IX. Again, we submit there was no proper basis for such a finding. There was no evidence that the presentation was not circulated more widely or that it was not available to potential competitors. Moreover, it must make no difference whether those to whom the business opportunity became available were potential competitors or not. So the criticism, the first criticism is the judge had no proper basis for such a finding. You then see that my learned friend tries to reverse the burden of proof. And then in paragraph 57, there's criticism of the judge's factual findings in relation to the gentleman's agreement, which is said to be, in about 6 lines down, manifestly fanciful. Now, can we go now to paragraph 102 of the judgment? So tab 7, page 15. And I should just note the starting point is that the grounds of appeal make no reference to paragraph 102. They don't seek to appeal any of the factual findings made by the judge in paragraph 102. So there is no appeal against the factual finding lines 5 to 6, in lines 5 to 6 of 102, that each of the AICF presentation and the fund fact sheet was intended by Illiquidx, Altana and Brevent to be a confidential opportunity to be presented to serious potential investors. There's no appeal against the finding that it was not intended to be and was not available to potential competitors to IX, nor against the finding, 3 lines from the bottom, that the tenor of Mr. Kastner and Mr. Robinson's evidence was that such a gentleman's agreement existed but was not reliable. Now, just pausing there, your lordships are invited to reject as manifestly fanciful the finding that a gentleman's agreement existed, which the judge also refers to as a general understanding in the industry, in circumstances where you haven't seen the witness statements of the 4 witnesses on whose evidence those findings are based, or the transcripts of their evidence. But you're invited to reject the judge's conclusion as to what that evidence shows. Nor is there any appeal against the finding that the teaser marketing was intended by them, i.e. Mr. Kastner and Mr. Robinson, to be confidential. Nor is there any appeal against the finding that the confidential information in the presentation retained its value. Now, there are 2 key points that arise out of paragraph 102, which we say present an insuperable problem for the appellants. And the first is the judge's finding that these materials remained relatively secret because they were not circulated more widely. Now, relative secrecy is a relevant test in the law of confidence, as the appellants acknowledge in their skeleton at paragraph 36. And in our case, as the judge found in paragraph 102, and it's not appealed, the information did retain its value as confidential information. And that was demonstrated on the appellant's own evidence, because Mr. Robinson and Mr. Kastner gave evidence, which the judge refers to in 102, that although they were willing to send the marketing materials to potential investors, they wouldn't have shared the materials with potential competitors. And can you just go to our skeleton, where we set out the references? It's in our skeleton at paragraph 40. 40 little c is where we deal with it, and we refer to the supplementary bundle, tab 42. Can I just take you very briefly to some of Mr. Robinson's evidence in cross-examination? So tab 42 in the supplementary bundle, and page 233. And in the first sort of 6 or 7, line 6, so this is the 29th of July 2019, you sending out the fund document. Then you see down below your email, it also says confidential again. Do you see that? Agreed. So we have many, many examples of this. I'm not going to trouble you with any more, but it's absolutely clear that you regarded the content of those emails as confidential at that time, and that's why you used the word confidential multiple times, isn't it? I would have preferred them to stay confidential. Yes, correct. I did consider that. I consider them, yes. You consider them confidential. Yes. Question, yes. That was because you didn't want the idea, the strategy that you were advising, widely known about beyond those to whom you were sending the emails. Correct. You of course, would not have sent and didn't send this presentation to potential competitors, did you? No. If Illiquidx had suggested that they might send it to potential competitors, you would obviously have objected to that. Obviously, yes. So, yes, the information had been shared with selected potential investors, but the appellant's own actions showed that it remained important to them to keep the information away from other categories of individual. They wanted to retain the value of the information, which of course makes absolute perfect sense when you are in the early stages of marketing a novel type of fund to investors. Obviously, you don't want people who might set up a rival fund to get wind of it. And so the upshot is that this is a case where the parties had a legitimate interest in withholding the information from some categories of potential recipients. And so applying the relative secrecy principle and supported by the authorities that we've set out in our skeleton at paragraphs 48 and 56, that the judge was absolutely right to find that the confidential information retained its value, and that finding isn't appealed. So the information had not entered the public domain on the judge's construction of public domain, which is the right one. So that's the first point. But the second key point is that the judge made a host of factual findings about the conditions under which the investors received these materials, of which confidentiality markings were but one. Now, most importantly, he records the evidence of a general understanding in the industry, this is the gentleman's agreement, that such material was confidential. And the evidence was from two witnesses from Illiquidx and from Mr. Robinson and Mr. Kastner. So there was consensus, it was on both sides. And it follows that the recipients, the potential investors, would also have had this general understanding. And this, of course, reflects how business in the city is done. You don't send potential investors NDAs. And can I just ask you to look at paragraph 112 of the judgment? This is in the section on trade secrets. It's a great disappointment to Mr. Vinyl, who is going to be dealing with trade secrets, that he's been deprived of this pleasure, but at least we have the pleasure of referring to paragraph 112. And line 3, you see Mr. Robinson gave evidence that it was impractical to require NDAs from potential investors when sending out marketing presentations. Absolutely. That's why you have a general understanding, so that city folk can seek investors without NDAs and yet maintain confidentiality. Now, just going back to paragraph 102, in addition to the general understanding in the industry, the materials were marked strictly and confidential. So this provided confirmation of the general understanding. And that's why I don't think we need to get into debates about how prominent was the notice, but it might be worth just looking very briefly at one short passage in CF Partners in the Authorities Bundle at tab 10. And if we can go there to page 221. This is in the section where, page 221, in the section where the judge is dealing with claims based on abuse of confidential information. And at little item 4 at the top, he says the information that Barclays received from CFP in written form was marked strictly private and confidential, although marking of confidential will not of itself confer confidentiality because the description is not definitive of the inherent quality of the document. A confidential marking will help establish that the recipient of a document is affected by an obligation of confidence. So I do rely on that, but in any event, it's confirmatory of the general understanding in the industry. Now, going back to paragraphs 100 or 102, but in fact I just want to take you to 101 because we've got a further material factual finding in paragraph 101. It's in relation to the Kanema Capital presentation, but it must apply equally to the documents in paragraph 102, and it's that the circulation was clearly intended. I'm sorry, my lord, in my excitement. So paragraph 101, the circulation was clear. It's five to seven lines down. The information was clearly intended to be treated as a confidential opportunity to serious potential investors. So what we've got is on the judge's factual findings, the combination of these factors is it was clear to recipients that they were being presented with a confidential opportunity for the specific purpose of being asked whether they wanted to invest. And the audience was potential investors, and they had notice that the information was confidential. And if you ask yourselves, would any of them have reasonably thought that they were being given information so they could use it however they pleased? Could they use this information to set up their own fund or tell their mates to set up a rival fund? Of course they couldn't. And importantly, they didn't do so because the judge found that the information didn't, in fact, become available to competitors. We see that in the first sentence of paragraph 103. And in the light of these findings of fact, none of which are appealed, it's simply not open to my learned friend to contend that the AIC presentation and the fact sheets entered the public domain. Even on his construction, he's got no basis on which to invite my lords to find that the recipients of these documents were at large to use them in whatever way they chose. He cannot go behind the findings of fact. And of course, there's also the additional factor he's got to overcome, which is that the judge's non-appealed finding in paragraph 95 stands, that the business opportunity was not widely known in the market. That's another tension for him. Now, I should at this stage just briefly address one further point that my learned friend made yesterday, which he said was part of the factual matrix for the NDA, being that the parties knew that they would be sending out some materials to potential investors. And the submission that my learned friend made was that if the parties knew that they were going to send certain materials to potential investors, they couldn't have considered those materials confidential. Now, that just doesn't follow, but it's wrong on the undisputed facts. Mr. Robinson and Mr. Kastner confirmed in their oral evidence that they did consider the marketing materials confidential. And at paragraph 102, the judge made the unchallenged finding that they were intended to be confidential, including by the appellants. So they've got that factual difficulty, but the submission is also wrong because of the structure of the NDA. The NDA expressly allowed the parties to use the confidential information for what the NDA called its permitted purpose. And it was common ground at trial that that included presenting the opportunities to investors. And so it's nonsense to say that although the parties were allowed to use the confidential information for the permitted purpose, marketing to investors, as soon as they did so, the information was no longer confidential. That would just run coach and horses through protection of confidential information in the NDA. And we've dealt with this in paragraph 54 of our skeleton. So the point that the parties always envisage sending out some marketing materials to investors is a point in our favour, not in their favour. Now, that deals with the second of the 6 items. Now, the first of the 6 items, the same points apply. Can we just go back to the grounds of appeal, page 17 in tab 1. So this is 2(1). And my learned friend there says the judge wrongly held that the distribution of marketing materials by AX prior to the JV did not result in the context of the marketing materials entering the public domain. And so this is a reference to the Kanema Capital presentation, and which my lords have obviously seen, and you've seen the legal disclaimer in the first sentence and the marketing marking at the bottom. Now, can you just go to paragraph 101 of the judgment, where the judge deals with this document? We've already looked at some of it a moment ago. Now, you've seen that the grounds of appeal make no reference to paragraph 101, doesn't seek to appeal any of the factual findings made by the judge, and in particular there's no challenge to the finding that the CCP remained relatively secret because it wasn't circulated more widely, or that it was not intended to be and was not available to potential competitors, or that it retained its value. In any event, the judge's factual findings were entirely justified on the evidence before him, which isn't before my lords. Can we then just go to my learned friend's skeleton to see how he deals with this in paragraph 55? And
you say that the things that the judge said about the gentleman's agreement, etc., in paragraph 102 also apply here?
yes.
Is there any reason why that should be different?
No, there is no reason. I think actually also, if you look at the schedule when he deals with the Kanema Capital presentation, which is item A, is page 124. Is it permitted disclosure pursuant to clause 1.1 of the NDA? No, for the reasons given in the judgment at 100 to 102. So he clearly takes all of those paragraphs as applicable to this as well.
And I suppose it may be said that when he says in 103, these marketing materials, he's covering everything that he mentioned in 100.
Yes, I think that's absolutely right.
He calls them marketing materials.
Exactly. He's dealing with both the Kanema Capital presentation and the AICF presentation and the fund fact sheet.
Yeah.
So if we go to my learned friend Skeleton at paragraph 55, and we see that the criticism is that the judge had no basis. There was no evidence for the judge that any of the recipients had not, in fact, towards the bottom of the page, the judge had no proper basis for making the above finding, and he erred in doing so. So he had no basis for the factual findings in paragraph 101, and he then says the court should review the documents and form its own judgment as to whether the business opportunity was thereby placed in the public domain. Now, that is not what this court should be doing, particularly where you don't have the evidence before you, as was before the judge. You simply don't have any of the complete evidence, and indeed, the grounds of appeal don't challenge this paragraph. So you shouldn't be doing what my learned friend invites you to do. And indeed, paragraph 55 doesn't identify any evidential basis for criticising the judge's factual findings in paragraph 101, other than the argument that the confidentiality notice is too small. But that's just simply a bad point, because the legal disclaimer made it clear in the first sentence that the document couldn't be reproduced or sent to others, and it was reiterated by the confidentiality notice marking, and there's also the gentleman's agreement. And then paragraph 55, he again tries to reverse the burden of proof, which clearly lies with him, and he speculates that it's entirely possible that the recipients of the CCP forwarded it to others. Well, I mean, that's hopeless, given that the burden of proof lies with my learned friend. Now, then in the last sentence, there's the suggestion that IX's promotion had inevitably released the idea into the wild. I mean, that is utterly unsupportable, including, given the judge's various non-appealed findings, that it remained relatively secret. And indeed, the argument that it was generally accessible because it had been sent to 17 potential investors is, we say, quite ridiculous, given the findings made by the judge. And again, here, there's also the additional factors to overcome, namely the judge's unappealed finding of fact in paragraph 95 that the business opportunity wasn't widely known in the market. So that's the first two items. We then come to the third of the 6 items, if we can just go back to the grounds of appeal, page 17, right at paragraph 2(3). And so the judge wrongly held, the argument is the 2 Bloomberg documents described London hedge funds and other investors bidding on such debt despite US sanctions, hence the business opportunity was in the public domain. Now, can we take the 15th of February 2019, we'll deal with it chronologically, take that article first. And if you can just go to the appellant's skeleton argument at paragraph 60, where he deals with this article, and he says, published on 15th of February, clearly disclosed the business opportunity was available to fund investors despite sanctions. Trading in notes from Venezuela ground to a halt earlier this month after the Treasury Department imposed rules that forbid US persons from purchasing securities. The article included quotes from multiple investment managers which indicated they were well aware of such investment opportunities. Now, this article, although referred to in the appellant's pleading, and in the trial bundle wasn't referred to anywhere in their written or oral opening and closing submissions or in their evidence. So having decided not to advance any arguments at trial based on the documents, we say it's not open to them to assert there was a demonstrable failure by the judge to deal with the document. And it's certainly not open to them to use the document to claim that the business opportunity was in the public domain. If that was a point they wanted to make, they should have made it at trial. It's too late now. But in any event, there's no suggestion in paragraph 60 that the article said anything about either the ability or the commercial desirability of setting up a fund to trade Venezuelan debt. Still less did it say anything about the further strategies identified by Illiquidx and referred to and found by the judge for setting up and marketing such a fund, such as the competitive edge given by the knowledge of the need for protective proceedings and so on. So the highest they can put the case is that the articles show that some hedge funds, not necessarily set up for the purpose, were trading Venezuelan bonds. But that's simply not the business opportunity as articulated by the judge. Then coming to the 24th of July article, if we can just look at their skeleton at paragraph 59. If I can just invite my lords to read that.
So paragraph
59. Now, this simply doesn't engage with the business opportunity as articulated by the judge. Now, my learned friend's submission about this document yesterday was, and I quote, "In terms of business opportunity, setting up a fund to trade in distressed Venezuelan debt, it shows there were others out there doing it." But the article doesn't refer to anyone setting up a fund to invest in Venezuelan debt, and it doesn't disclose the strategies for doing so, which are part of the business opportunity. So it just doesn't get off the ground. And indeed, even if my learned friend persuaded your lordships of the single sentence articulation of the business opportunity, you're being asked to reject all the evidence the judge considered, including the evidence of the witnesses, which was to the effect that those in the industry considered it wasn't possible or desirable to set up a new fund to invest in Venezuela. And you're asked to do that on the basis of this one document. So you're being asked to reject the evidence for the judge without even having seen it. So it's just, we say that it's hopeless. Can I come to the fourth of the 6 items? And if we just go to the grounds of appeal, page 17, core bundle, tab 1. Failed to have regard to the fact that the protectability of the business opportunity was inconsistent with his own finding that the only opportunities disclosed by the claimant to the defendants, namely the Venezuelan bonds which could be traded, were excluded from confidential information under paragraph 1.1 as being in the public domain. Now, we just go, well, we don't need to go to my learned friend Skeleton because paragraph 62 he just cross-refers to paragraph 43. I should just say, as a starting point, the appellants never argued at trial that because it was in the public domain that the 38 bonds were tradable, it was therefore also in the public domain that one could set up a fund to trade them. Now, to be fair, they did argue that there's no difference between buying bonds and setting up a fund to buy bonds. But that's a slightly different point. They didn't articulate why. They didn't argue that because the purchase of 38 bonds was in the public domain, it therefore follows that the setting up a fund was also in the public domain. So my starter for 10 is that this is another argument that isn't open to them, but I do accept that they did argue that there's no difference between buying bonds and setting up a fund to buy bonds, so it may be that my lords aren't particularly attracted by that. And the reality is I've got to deal with the substance of the argument anyway. So can I deal with the substance of the argument? And the headline point is that the mere existence of these 38 bonds and their status in relation to US sanctions didn't disclose the fact that it was both possible and commercially highly attractive to set up a fund to trade undervalued Venezuelan debt. Still less did it disclose the strategies, the know-how for doing so. The list of 38 bonds, which Illiquidx identified for Mr. Robinson because he was previously unaware of them, was in the public domain, and the judge made that finding in the schedule at B1. So a member of the public looking at the OFAC website could come across a list of the bonds. But a list of bonds which could be traded without breaching sanctions tells the reader absolutely nothing about whether it's commercially attractive to trade them, nor about whether it's possible or desirable to set up a fund to trade them. It doesn't, without more, disclose the idea of setting up a fund, or the rationale for doing so, or the strategies for unlocking their value. Why should anyone reading the OFAC website, if they manage to understand what it said about these bonds, why should they choose to set up a fund investing in those 38 bonds specifically out of the universe of bonds and other investment opportunities which they could buy into? And so the potential relevance of the list of 38 bonds could only fall into place, as it did for Mr. Robinson and Mr. Kastner, after a party, Illiquidx, had done the background work identifying why investing in Venezuelan distressed debt was a jolly good business idea, either rationale, and establishing whether, and if so how, a fund could be set up to invest in Venezuelan debt, including these bonds. So what strategies, what details were needed for setting up and marketing such a fund. And this, of course, is confirmed by the factual history as to how the appellants came to understand the business opportunity and why it was such a jolly good idea. And I took my lords to various paragraphs where you see them starting off in total ignorance, then they moved to scepticism as to whether or not it could be done, then they slowly moved to full appreciation once they've been educated, at which point they're happy to set up a fund and offer it to potential investors as the trade of the decade. And this reflects the fact that even though the 38 bonds were tradable, the market simply hadn't appreciated that this debt represented this fantastic opportunity. And expert fund managers hadn't realised that it was possible. And that is confirmed by the fact that the evidence before the judge was that only one other fund, Copernico, had been launched to trade Venezuelan debt. If this was such a fantastic opportunity and it was known in the public market, it was all in the public domain, why did only one other fund in the world do it? The answer is that people didn't know it could be done or how to do it. It wasn't in the public domain. That brings me to the fifth of the sixth items. We're nearly there, my lords. This is the telephone transcript of the 10th of May 2019. And can I just ask you to go to the appellant's skeleton, paragraph 53. This transcript records a call between Mr. Amore, Mr. Robinson and Mr. Kastner. Mr. Amore said that he'd spoken to hedge funds the previous week in New York. They said to him, "So why don't you set up your own vehicle? It's crazy that Europeans are not setting up these things." When this was put to him in cross-examination, Mr. Amore agreed that very specialised hedge funds were aware of this opportunity for Europeans and non-Americans to invest in distressed debt. Mr. Amore also agreed that the desirability of investing in distressed debt was well known. Now, the starting point is that it's not clear that the appellants submitted at trial that this conversation with specialised hedge funds showed that the business opportunity was in the public domain. Can I just ask you to look at supplemental bundle, paragraph 44, tab 44. And if you go to 247, And now, I should just highlight, you can't look at page 246 to give you any indications to the background as to what's on page 247, because as you see in the top right-hand corner of page 246, it's page 32 of the transcript, and page 247 is page 91. So all you have got is page 247. And lines 4, Mr. Justice Raja, just join the dots. This is to my learned friend. Where is it actually said they knew how to buy bonds or they could buy bonds? I mean, this is an article, so they're obviously talking about an article at this stage, which says you can't. So people are poised, industry pros are poised. That's not necessarily the same as a fund which is seeking to attract investment. Mr. Moody Stewart, well, perhaps, my lord, the simplest way of addressing this is because I commend the cross-examination to you, because they're poised and they can see it as an opportunity to invest. And they're wondering why, you know, they think they can't, but are wondering why European funds aren't, which suggests they know it can be done. They're wondering why other people aren't doing that. That was the bit in the transcript that Mr. Amore, US hedge funds talking about other people saying, why aren't they doing it? And that's why Mr. Amore accepted it was general. It was a general, the opportunity was known, but actually I can short circuit all of this and then he goes to something else. Now, that's pretty light fare for suggesting that they invited the judge to find that the conversation showed that the business opportunity was in the public domain. But in any event, let's assume that a couple of unidentified US hedge fund managers who were themselves prevented by sanctions from setting up a fund to invest in Venezuelan debt said it's crazy that those European chaps aren't setting up these things. Well, that only goes to support Illiquidx's case that Europeans, the ones who could do it in a sanctions compliant way, either didn't realise there was an opportunity or didn't know how to execute the opportunity. Indeed, it's not even clear whether these unidentified persons in the US knew that it would be possible to set up a European fund, nor is there any indication that they were aware of the strategies identified by Illiquidx and found by the judge. So regardless of who wins on ground one, this telephone call doesn't establish that the business opportunity was in the public domain. That brings me on to the sixth of the 6 items, Professor Olivares Caminal's legal advice. Now, if you just go to grounds of appeal, paragraph 2.6, on page 18 of tab 1, with regard to the advice given by Professor Olivares Caminal as to the effective limitation, prescription periods and the differences between fiscal and the judge failed to have regard to the fact that all such information was publicly available at the date of the alleged misuse. So it's not suggested that this legal advice meant that the business opportunity itself was in the public domain. So all they're seeking to argue, this is their salami slicing, they're seeking to argue that limitation and prescription was in the public domain, and therefore you can take that separately and somehow it has some effects. But so our position is that even if they were to succeed on this point, it wouldn't entitle them to have the order set aside. But can we just go to their skeleton at paragraph 64? And the judge was wrong to hold that anything in Professor Olivares Caminal's legal advice added anything to the business opportunity that was not already in the public domain, thus excluded under the NDA, etc., etc. And so it's a narrow attack on the judge's finding in item W of the schedule to his judgment. Now that's presumably both the limitation advice and the trustee and fiscal agent's advice. I've made the point that there's actually no appeal in the grounds of appeal against those findings. But in any event, it's a bad point, because insofar as the point has any relevance, it's because the appellants recognise that Professor Olivares Caminal's legal advice actually fed into the business opportunity. Because if you can go, can I just take you back to the advice itself? If you go to the limitations document itself, at supplemental bundle tab 21.1. And it's really the final paragraph that I want to focus on. The Altana and Fund will assist you not only in providing unique access to promising return opportunities in the distressed sovereign debt of Venezuela, but also managing the debt instruments to protect creditors' contractual rights with the aim of achieving a greater return. So the professor isn't just advising as to limitation, he's proposing a text which explains why the limitation period is a reason to invest in the proposed fund. And if you then go to item W1 of the schedule to the judgment at Core Bundle tab 7, page 134 to 5, and we see at the bottom Professor Olivares Caminal's legal advice, and a fiscal agency structure meant that it was the responsibility of bondholders to bring proceedings, prevent that a sanctions compliant fund would have the advantage for investors of being able to bring proceedings on their behalf to avoid prescription, etc., etc. And he notes that, sorry, I'm trying to find, there should be a reference. Sorry, what? 130. Oh, 135. Sorry, I do apologise. Yes, on page 135, under is it Illiquidx's confidential information? And it then says an explanation of the ramifications of fiscal agency and prescription was included in slide 12 of the AICF presentation. And if we just go to tab 22 in the supplementary bundle, at page 121, and we've already seen this, and you can see in the bottom bullet point on page 121, it is where it says the Altana Illiquidx Kanema Fund will assist you not only in providing unique access, etc., etc. And so that's the text that the Professor recommended. And so in the schedule at W1, the judge found a sanctions compliant fund would have the advantage for investors, etc., etc., and he referred to that as the diamond that was not in the public domain. And we say his finding there was unassailable and it's not appealed. So that deals with all 6 of the items in ground 2. We say the appeal in this regard is hopeless. I should finally just make this point. I said to you when I was dealing with the 3 items in ground 1 little 6 yesterday that none of them discloses the business opportunity as found by the judge, and that was at a stage where I hadn't yet gone through the business opportunity as found by the judge. I've now done so and taken you through the judge's findings, and it's absolutely clear that none of the 3 items shows the business opportunity to have been in the public domain. They are 3 instances of salami slicing, but entirely fail to disclose the business opportunity as found by the judge. My lords, unless your lordships have any other difficult questions, in which case I'll ask Mr. Vinal to deal with them, I will sit down.
Very thank you. Mr. Medici.
My lords, so the starting point in my reply is the exchange between your lordships and my learned friend and the case my learned friend has put forward now about the business opportunity in some way going beyond the limited business opportunity that he advanced before the judge, and him saying that there's more in that, and also to address you on why that matters, which is in fact, my Lord Justice Arnold's question, if you're talking about particular bits of detail, if we're right about the business opportunity at that high level being in the public domain, why does that matter if there are individual findings in relation to particular parts of detail? First of all, I'm going to do the why it matters. And why it matters, because the detail, as held by the judge to be misused, are particular points that may have been used, and he held were used in promoting the fund, but they don't remove the fund itself. They don't attach to the business opportunity of setting up the fund itself. Okay? So,
try to follow that. Can you explain the distinction you're trying to?
So the distinction I'm trying to do is the business opportunity that the judge held that we misused at a high level, which is the primary point of our attack, is the opportunity to set up a sanction-compliant fund addressing Venezuela. I paraphrase, but that's...
Can I ask this question? Let's just take a hypothetical. Suppose this court were to uphold the judge's findings in the schedule.
Well,
All
yes.
right?
Yeah.
So we are all the ones that are helpfully colour-coded in red.
Yes, my lord.
What's left?
So
that you say makes a big difference from your client's perspective.
because then we look at what was, we're not talking about setting up the fund itself and competing in the market in the fund itself. We're talking about the use of the specific materials that are referred to and the specific parts of the confidential information that were identified in the detail in relation to each of those items. And so, for example, taking Olivares Caminal's advice, the professor's advice, that was used and held to be used in the promotion because it's within those, for example, the presentation, the fund presentations, well, French showed you where bits of that come in. It was used in the promotion of the fund. But in fact, in terms of the operation of our fund, there are, which will be addressed when it comes to any inquiry if we get there, what my clients actually did in relation to relying on either Olivares Caminal or in terms of deploying what's said as we've misused a multi-cell structure. Well, that's referred to in the promotional materials, but it's not something that our fund has. It's not a multi-cell structure the fund has used. So there's a difference between going through what is there that has been held to be confidential in the detail in the schedule, the red bits, as your lordship puts them conveniently in there, and the overarching business opportunity, which is the opportunity of setting up a fund at all. And that is important when it comes to the consequences of the findings. And that's why we've addressed the business opportunity at the level of generality, which is the level of generality deployed by my own friend in closing. It doesn't go further than that sentence, and I'll show you why and how. There is no respondent's notice saying that business opportunity should be extended beyond that because he had a fallback position in relation to what it might have been. And the judge took it at that level of generality. And so we say that success in relation to the business opportunity, which is the big idea as was originally trying to be run and has mutated through to closing, success from our point of view in relation to the business opportunity is valuable and important because the items within the schedule allow us then to say what is in fact the case, which is that those particular parts did not lead to damage that is recoverable or significant damage. So that's why it matters. And it's really important. My learned friend has done what he has done throughout this case, which is attempt to put this at the highest possible level to get a generalised finding. And then when that looks shaky, he says, well, let me take you to the detail small d within the detail, within the bits and the business opportunity. And he then says, look at what's within the fund detail, as the judge referred to it. He says, look at what's in this particular presentation, look at these things about the rationale, about the investment strategy, none of which are within the business opportunity as relied on. And if what's said is we misused the presentation, then we can argue about what's in the presentation. So that's why it matters. Now let me show you why my learned friend is again ducking and diving in this way and trying to call on the detail to bolster his position on the overarching business opportunity point. So my learned friend took you to transcripts of his closing to show you how the business opportunity that he relied on at trial emerged. And he relied on them to show, well, look, I didn't abandon anything. In my submission, I'll take you to them briefly. What they show very clearly is that he was limiting his case to what's been called the simple sentence, to the business opportunity as expressed by the judge, and not any rationale behind it, but that he maintained open the possibility of a further fallback case, supplementary cases. And he referred to the business opportunity as the core submission made, and that is what the judge addressed. That is what the judge made his findings in relation to, and that is what we are principally attacking, though we have also attacked certain aspects within the detail, as I addressed you. But let me just show you that. So it's not, well, learned friend says, well, I didn't formally abandon them. He didn't say, I no longer pursue some other secondary version of the business opportunity, but the judge decided the case on the business opportunity, and my learned friend's respondent's notice does not say, by the way, if the judge is wrong on the business opportunity, he should instead have held on other grounds that the broader business opportunity in a hat with a moustache with a little extra bit here or there, is something upon which we rely. So let me show you his own transcript that he relied on to make this point good. This is in the blessed further supplementary bundle, tab 5. So on page 20, we have at Mr. Green's submission at line 7, sorry, let me get there. Says, so what then, Mr. Green says, so what then is the confidential information which Illiquidx claims to have provided to the defendants? Now, my lord, as I said, the primary answer, so this is primary position, is the opportunity to set up a fund to buy sanctioned Venezuelan debt, including sovereign and paid evasive bonds, which at the time were undervalued. And then there's a question of just bonds, and so he says, no, it's not just limited to bonds. And then Mr. Green goes on at 18. Now, the defendants were also informed, as pleaded, so this is in the raft of stuff in the detail. And my Lord Justice Arnold, I'll address you on that paragraph 83, I think it is, when you look at the pleading point. But the defendants were also informed, as pleaded, that there was a strategy for how to set up a fund in that space, which included, for example, obtaining a legal opinion stating the fund was sanctions compliant and understanding the effect of the prescription clauses. So he goes on and says, we list all the elements of this strategy, base of the page. So this was in his opening statement when they were still running the full-throated business opportunity as fully pleaded, which was everything in the detail. And then he says, base of the page, all of which appear in the detail, and we've identified the pleading. But the core opportunity, my lord, distinction here, this is what the judge held and found, was to set up a fund to buy sanctioned Venezuelan debt and other instruments, including bonds, which were then undervalued. And so that's the case he was running. And again, this isn't just a one-off. Wherever my learned friend takes this, if we look at behind tab 6, I believe to do, in this bundle, further submissions where he's addressing what was the confidential information. Page 24, the judge says, Mr. Justice Raja, well, perhaps we can come back and discuss a bit more. At the moment, I understand from you the contention is that the business opportunity is the idea of a fund. Mr. Green, at the highest level. Mr. Justice Raja, yes, but secondarily, fallback position, not what the judge held. Secondarily, if I need to go beyond that, which I say I don't, but if I need to go beyond that, was also the investment strategy for the purposes of monetising that. We've identified all of the relevant parts in paragraph 72 of our own. So, clear distinction drawn between business opportunity, as his core proposition as ruled on by the judge.
I think one needs to read on and see what the judge then said. Is the judge says, well, the difficulty in idea is anybody can have an idea. What makes it special, as I understand your client's position, is they had a special insight as to how to make the idea work.
So, but we're just talking about whether that strategy was communicated. I'm just addressing what my learned friend did in terms of the case as advanced, and behind tab 7, he addressed this is all within the same day. It's a few pages further along. Page 28.
But then it goes on to the question that I raised about, is it the compilation or is it the component parts? And the answer given by Mr. Green at line 22 is they put it both ways. They say individually every item is, and compilation as well.
Well, my lord, and to be fair to my learned friend, yes, he said individually every item is. That is the detail. The detail was a series of every single item listed out, not every single part of every item, the specific parts identified, written down in the schedule in Racker 1,
All right,
as to which they are.
can I cut to the chase? Because, I mean, this explains why it's not your case, as you were very clear and candid about in opening the appeal, that the case was not pleaded. So the case you're presenting is that although it's open to the claimants on the pleading, in some way the case has been limited in closing submissions. But at the moment I'm struggling to see that, because on the contrary, what we see is Mr. Green constantly saying, but we also have these other bits in our pleading.
Well, I don't, because he says there are these other bits in our pleading. There are these other cases and his fallback cases, but his primary case that he ran, and I can show you again. I mean,
I just wonder though, before you do that, whether also there's a passage on the next page, 26. This seems to be, because this is the way the judge puts it. I think your big picture point, your business opportunity point, or the big idea point, is the idea of a fund plus our special insight as to how to operate that fund, or our special insight as to why that fund might work. So that's the fund, the how, and, if you like, the overall likely success or otherwise of that fund. And then he says, well, it is.
So, but what Altana was doing throughout this, and we look at the result in the judgment, which is the judge recording this is the business opportunity is run, and I'll show you again the bit in the costs decision where he says, look, this is what went on and a lot was abandoned, or was not formally abandoned, but this is what you pursued at trial, I paraphrase. Mr. Green ran a lot of different things at a lot of different times in a lot of different ways. The question is not whether he ran them all and refused formally to give up on anything, which is kind of the hallmark of what went on. It is that when the judge decided it on the basis of the business opportunity that he identifies as being the core proposition that Mr. Green advanced, and sets that out in the judgment, and he also decided it on the detail. So highest level, individual bits of detail. He decided both of those, but he was focusing on the business opportunity. Now, the learned friend cannot then say, well, I want to add more detail to the business opportunity. I ran those cases at trial, because he has no respondent's notice that says if the business opportunity falls, then on we go, and I can add these further bits which were open to me on my pleading. It doesn't matter whether they were open to me on his pleading. He ran them. The judge decided it on the approach that he sets out in the judgment, which deals with the business opportunity in that sentence, which is not any rationale, it is not any investment strategy, it is at that level of generality. And why I challenge that is because if I knock out that business opportunity at that level of generality, then we're down to look at the bits of detail. And it is certainly my client's position that that makes a significant difference when it comes to where we are on misuse. Whether or not I knock out all of the individual bits of detail, or only all of ours coming out, or whatever, the point is the business opportunity, capital B, capital O, as run by learned friend at trial, is something that is important and is the subject of our appeal, and it's not open to my learned friend to wiggle in and say, well, let me show you these bits of detail within bits of detailed documents that were part of how the business opportunity, as I've now landed on, were disclosed, because that's not how it was advanced before the judge. And I've addressed it. I'm not going to go back to how I say those paragraphs in the judgment should be read, where he's addressing what the fund detail is and so on. But in my submission, the judge was clearly distinguishing between business opportunity, BO, at a very high level of generality, and then the detail. And if the upshot, hypothetically, of your lordship's ruling on this bill were to be that the business opportunity, that standing cannot fall because at that level of generality it was out there, and because the judge did not consider the level of generality as a matter of whether it was in the public domain when he was looking at the question of public domain, you know? If your lordship held that that was not, that finding doesn't stand, then the detail findings, that's something we can deal with, and we'll have to deal with, on any quantum phase of this. But it is of value to my client. I don't resile at all from my position. Take a leaf from a learned friend's book. Don't resile from my suggestion that other bits of detail are to be challenged, what the learned friend calls salami slicing. But it is of value to address the business opportunity writ large rather than the schedule. And it's, so what the learned friend refers to in his submissions here, as we've seen them, he talks about secret source. He refers at various states. So just for the record, where my Lord Justice Miles was referring to this, the business opportunity. So there's a discussion as to what it might be. Ms. Green, well, it is. The secret source was that we went to them and said, by the way, and secret source was a phrase that cropped up a number of times at trial. It's in other bits of things. And if you look at the business opportunity, there is no source on the business opportunity at that high level. It's variable. The source, insofar as it exists, is within the detail. And that, we can argue about what the judge's broad findings of misuse actually translate to when it comes to any quantum phase, if that's where we get to. So that's why this is an important point on the appeal, and it's important that my learned friend can't segue from the high level description of what the business opportunity is, and bolster it by bringing in little bits of detail in order to maintain that overarching finding, because that's what he did. And let me just show you, I'll go to the paragraph in the judgment that my Lord Justice Arnold was looking at in particular. But before then, let me just show you again the point within the cost judgment where at paragraph 19, so this is behind tab 45 in the supplementary bundle, this is where Mr. Justice Raja addresses what was going on, and this is a bit I laughingly referred to the reference to me fighting yesterday's war, but between those two whole bunches, the sentence line, for in his closing submissions, Mr. Green dropped substantially all the detail without formally abandoning IX's case on the detail, and argued that the business opportunity was the high-level idea of a sanctions-compliant fund, which was evidenced by a few documents in the detail. That is, I'm just saying, if you want, it's not within his judgment, but it's the same man explaining what was behind his thinking. And my learned friend is quite wrong to say that what the judge was doing was finding that all of the parts of the detail that are dealt with in the schedule somehow are imported and uplifted into the overarching business opportunity, because that's not how he ran the case. Because, as I explained in opening, there were elements within that overarching business opportunity which combined everything as they started running the case that weren't even his idea. So find his client's idea, the finding of the custodian that allowed the fund to take place, the judge held that my clients were the ones who identified and brought that to the fund. And so he couldn't run it all together, the collation of everything. He could do each individual point, that's the detail, but he had to find a collation that was within his pleading and had been disclosed to my clients. And what he landed on was the core, the business opportunity that the judge addressed. And that's fine, but he stands or falls by that in the absence of a respondent's notice that allows him to go further. So that's the position. Now, my Lord Justice Arnold raised a point on on those particular paragraphs. I'm not sure if I need to go with the paragraphs in the judgment addressing the pleading point, and is it all one bit or is it a collation, and do you win if there are 4 points? Do you need to show all 4? Let me just give you my submission to show you what I say the judge was doing at that point. So this is tab 7. An increasingly ratty copy of this judgment. Paragraph 84 was the point on page 111. Was the point that Mr. Justice, my Lord Justice Arnold referred to. This is addressing the pleading and what was in there. So business opportunity here is as pleaded. And the pleaded case is the business opportunity is composed of the information listed in the detail. The detail comprises documents and is limited to passages in the documents which are identified in the pleading. So that is, even within that broad and messy pleading, that's what was said. And then 85 sets out what the business opportunity was. So what the judge held, and the approach was that the business opportunity as pleaded was a collation of all of the bits in the detail. And so we said that that would have to have been, you have to show, if you've got to rely on a collation, you have to show that collation was disclosed as collation. And you also have to show, and there was an argument about this, is the collation still confidential if none of it is confidential or some of it is confidential? The learned friend said and pleaded that even if none of the aspects of detail remained confidential, the collation, because it was a collation, could be confidential. Okay, so that's how he addressed it. And then, in closing, the limitation for 86 is plain, but Mr. Green, in his closing submission, sought to focus on the idea of a sanctions-compliant fund. We've seen that there. And that the business opportunity he submitted was the opportunity to set up a sanctions-compliant fund to exploit undervalued Venezuelan debt. And in my submission, that's what he landed on. That's how he advanced it. He had other fallback positions that we've seen in those bits of the transcript. The judge did not decide on the basis of those fallback positions. He decided only on the basis of this high-level point. We say he fell into error in finding that the business opportunity as so defined was still protected. And if my learned friend wanted to say, well,
I'm
I
a
want the
bit
business
puzzled by
opportunity.
that submission, because when we go on to 91, the judge says that details of the business opportunity are contained in particular, the 6 items that are comprised in what he defines as the fund detail.
So,
And then there's a positive finding in relation to that package.
so, my lord, the details of the business opportunity, as he's referring that, is not the business opportunity as defined. My lord, you made the very well-known point that a judgment is not a statute to pore over every word, but what he's dealing with here is describing, having already dealt with the pleading of how the business opportunity is a collation, the business opportunity at that level was disclosed at that level within these documents. And all he's saying, he's now addressing in 91, he's addressing the details. He's not addressing the business opportunity as having these extra details within it. And that's a submission I made in my opening, as it were, when I'm first addressing you rather than in reply, and I stand by that as to what 91 means. It is not a Trojan horse by which all of the fund detail parts are then imported into the business opportunity. The business opportunity remains general because that's what's decided.
Can I just ask another question?
My lord, yes, do.
If you look at, so he's identified those 6 documents there, which he calls the fund detail.
My lord, yes.
If you go back to the end of 86, you'll see that he says the business opportunity, so he calls it a package of information comprising the business opportunity. And he then goes on to say, and it's contained in an evidence, so contained in an evidence by several documents comprising the detail, such as, and then he lists 3 specific documents and various fund fact sheets. And he says see below, that's the same lot of documents as
Yes.
the fund detail.
Yes.
So he's saying, as I read it, that the business opportunity, as he's understood it, is actually contained in those documents.
Well,
But those documents clearly don't just say you could have a sanctions compliant fund to exploit undervalued Venezuelan debt. They clearly go beyond that.
well, my lord, they do. But it's clear. It's also clear from the judge's decision that the business opportunity is a limitation of the generality of what was previously run, and excludes parts of the detail. So
Those,
what he's
those
saying
might be the parts of the detail which are not included in those 6 documents.
Well, my lord, I with respect, I disagree on that, and it's not, in my submission, the correct reading of this paragraph. This paragraph is addressing whether this was open to them on their pleaded case. So the question is, could they shift from the business opportunity as broad and complicated, which would require the judge to address each and every part of it and whether it was disclosed in relation to my learned friend's choice, as we've seen in this, things to run that high-level business opportunity point. And he said it was open to them because it's disclosed within these. And it's true, at that level of gender, it's in there, but there's more. And it's plain that there's more within those documents. But that's not what my learned friend was relying on. And again, I it's a different judgment, but the judge's characterisation of my learned friend without formally abandoning them, he never formally abandons anything, without formally abandoning, okay, so just saying that he had limited the business opportunity as this was elements of the detail were dropped and it came down to this point. I think that's showing, that's why there was such a swinging penalty and cost against my learned friend in relation to what went on at first instance. So this is, it is the focus of the submissions at trial was my learned friend's core, the business opportunities we've seen in those. And that's what went on. That's what the judge decided. And at that level of generality, we say the reasons I've given, that business opportunity was not protected, was in the public domain, was excluded because it had been disclosed to my client. I would just address what my learned friend had said on numerous occasions about what is and what isn't challenged in my grounds of appeal. My grounds of appeal make very clear that based on the specific points that we raised, the specific documents we refer to, that the judge got it wrong when he was saying that the business opportunity was still protectable. Okay? So that's our submission. And that compendious, I don't have to identify each and every paragraph where the judge has said, and this, the business opportunity, this was the consequence, this went on. I was attacking the judge's finding that the business opportunity as defined was in the public domain, and indeed the bits of the detail were in there. And that's set out in the paragraph, following paragraph 2 of my grounds of appeal, when I say if he hadn't fallen into error, he wouldn't have held that the business opportunity and the detail were protected. So I'm not challenging to that if there are other specific facts that don't fall under the umbrella of the business opportunity or the bits of detail I've identified, then my learned friend can make his point. But be careful that my learned friend's a man for whom submissions can be made at one generality and then he requires very detailed points and then he moves up. This applies both to his approach to pleadings and his approach apparently to my grounds of appeal. So I do not accept that any point that I have run on this appeal is not fairly open to me in light of my grounds of appeal. And insofar as it may well be that your Lordship don't allow the appeal or against it, but it's certainly open to me on the grounds as run. There's any specific points for me to do. So I'm just checking whether there are other detailed points
Well,
to address.
I think one thing we would certainly appreciate your assistance on is not the point you've just been addressing, but a related point, which is in relation to ground one, so far as it relates to paragraphs 1.1c and d of the NDA. The submission was made,
But I didn't raise it,
that those points weren't run at trial.
my lord. It's in my note. I'm glad you brought it up. Having on it, let me show you why my own friend is wrong. First of all, let me show you my written closing, supplemental bundle tab 47. And at the back end of this may be the easy way of dealing with it, or I can go into more detail as we go on. And I wince whenever I use the term detail in the context of this case. So these are extracts from our written closing.
Sorry, can you give me the tab again?
Tab 47.
Thank you.
So, actually, let me deal with, rather than, so page 344. So, there was a lot in this case because of the way my learned friend had run it and the vast amount of detail that was in play. But remember that the reduction of this case to a business opportunity did not occur until closing. So we didn't know that was going on, hence my comment about fighting the last war. Within this table, we do, my learned friend is absolutely right, we're not saying clause 1.1c and d. We refer compendiously to information that's excluded under clause 1.1. But if you look, for example, the Canaima capital presentation, individual elements already known generally to the defendants. Okay? Known to the defendants that's C and D, either being provided to us or known before it started. So, and indeed, due diligence note. Individual elements not confidential at the level of generality which they're expressed, to imprecise, where specific enough, names of contacts, confidential information under the NDA but known to the defendants, e.g. Davis Polk, or public domain, your declarability. So we were running these points in terms of 1.1c and d, and they were deployed within these, and in particular, my own friend made some play about multi-cell and the claims management one. This is R. As we go through the alphabet, this is on page 61. Confidential information. So, confidential information, just to be clear, when I conceded at trial that matters were confidential information, it's a question of whether it fell within the definition without exclusions of confidential information on the NDA. And given the breadth of that, it was pretty hard not to say things were confidential information as defined. The question is then, is it excluded? Confidential information, so yes. SPC and PCC, so these are the single cell and multi-cell structures and other fund features are commonplace, public and well known to the defendants. All relevant information have been published via it. So that's compendious. You've got two things, things that were known to us, so multi-cell. My client said they knew about multi-cell, wasn't challenged, it's tried. And there is no secret source at all in running a multi-cell fund. You could do anything that could be done in multi-cell and could be done with a single cell fund. But here, these are matters that were known to the defendants, but also we say all relevant information has been published via the Canaima capital presentation. So at that point, that's detail published in the Canaima capital presentation. If I were right that the detail, that those sending it out to investors had published that in its entirety, then that would have resolved the detail. That's separate from thinking whether the publication, the sending out of those presentations was sufficient to remove confidentiality from the high-level business opportunity. But it's quite wrong from a learned friend to say, I did not run 1.1c and d at trial. And indeed, if we see, I mean, the judge, unless he was, we say he didn't focus in properly on these things, but when you look at the judgment, I can find where I put it, when he refers compendium at the end of his finding at 103, when he's dealing with the marketing materials sent to selected investors, says, I do not consider that sending these marketing materials, so this is on page 116 behind tab 7, yeah? Made them generally accessible to the public or to other investors who did not receive them or to competitors. In conclusion, neither the business opportunity nor the fund detail, so I'm just pointing out these are findings firmly against me, was in the public domain, brackets, or otherwise within the disclosure permitted by section 1.1 of the NDA. So we say he wrongly failed to focus on certain aspects, but he certainly had it in mind. It's not like this was never run before him in the schedule to our closing or addressed in these matters. My learned friend is quite wrong.
I'm sorry, I do have to interrupt at this point. If my learned friend is saying that as regards the items at ground 1, little 6, A, B and C, he invited the judge to make findings that they were within the scope of 1.1 C and D, please could he identify where in his closing submissions or elsewhere he did so? He didn't.
So the multi-sell fund, so this is within this one. So I'm going to do this to my left hand. But the multi-sell fund, we've looked at R, which is to do with multi-sell funds, and SPC and PCC, and these matters were within, that's in the schedule to the closing. And in my grounds of appeal, that's precisely, find it, that's B. We say this is the unchallenged evidence, this is to do with the use and purposes of multi-cell structure. Well, I've only got so much time, but that's a point. I've done it. So, now, the only other point, which I think there's a risk of being lost in all of these and came through in my learned friend's submissions, is there is a suggestion that the fact that the business opportunity refers to sanction compliant fund, that sanction compliance has some mystery or a secret source, as my learned friend puts it. The only mechanism for sanctions compliance that was ever communicated to my clients as established, dealt with by the judge, was in those 38 bonds which were excluded from the sanctions. So when we're talking about sanctions compliant, all funds that trade, if they're going to trade, they have to be sanction compliant. It's a regulated industry, so there isn't some magic about sanction compliance fund or having a sanctions compliant fund. It's a way we'll want to make this sanction compliant. It's through what are the things you are trading in that are they bound by sanctions? And so if you have publication of these specific opportunities, the only ones ever disclosed, and they are held by the judge to be in the public domain and known to be sanction compliant, albeit not known by my clients, as it was held, then that addresses the sanction compliant nature. It's inherent. There was no secret source concerning sanction compliance disclosed. My lords, I can't in all conscience take advantage of that my learned friend finished early to continue, unless there are any further specific questions you have for me on the point.
No, thank you very much. So the parties are to be congratulated on finishing within time. Thank you for that, and thank you for the detailed submissions we've received both in writing and orally. So we acknowledge the work not just of those who have spoken, but those who have not spoken. We will obviously take time to consider our judgments in this case, and as I'm sure you're all aware, the procedure will be that you will get a draft at some point, and I'm not promising you when, I'm afraid, and that will be for the purposes of correcting typos, wrong dates, that kind of thing, not for the purpose of re-arguing the case. And that will be under embargo, and I'm sure you all know the importance of observing that embargo. In addition, at that stage, we will ask you to try and agree a consequential order. If you cannot agree a consequential order, then please file brief written submissions.
Arnold, thank you very much.
Court rise is able.